Welcome to the third in our series of 4 short videos in which we take a bite-sized look at some of the key themes emerging from the courts over the last 12 months. In today's video, Ed Davis, a partner in our finance litigation team, will be discussing 2 recent decisions concerning ISDA Master Agreements.
Hello, I'm going to talk briefly about 2 recent cases in which the English courts have considered the termination and closeout provisions of ISDA Master Agreements. In summary, under an ISDA Master Agreement, following an event of default, there is either an automatic termination or the non-defaulting party can serve a notice designating an early termination date. There then has to be a determination by the non-defaulting party of the compensation that is owed by one party or the other. This is done by closing out the transaction, which involves determining gains or losses in replacing or providing the economic equivalent of the terminated transaction. Once that is done, a statement is served setting out the calculations. The first case I'm going to consider on this topic is a High Court judgment in Goldman, Sachs and Videocon Global, in which the court considered whether a termination notice was validly served and whether a calculation statement accorded with the terms of the 1992 ISDA Master Agreement. Goldman Sachs and Videocon had entered into 2 currency option transactions on the basis of the 1992 form of the ISDA Master Agreement and the 1995 Credit Support Annex. On 23rd of November 2011, Goldman made a margin call under the Credit Support Annex. The margin was not paid, so Goldman delivered a Notice of Potential Event of Default dated 28th of November 2011, and then a notice designating an early termination date. This notice designated as the early termination date 2nd of December 2011, or if this notice is not effective on such date, the next local business day on which the notice is effective. On the 14th of December, Goldman delivered a calculation statement. Videocon did not pay the amount claimed, so Goldman started proceedings and sought summary judgment. Videocon raised a number of defences. First, it said that by the time the early termination notice had been delivered, the 23rd of November margin call was no longer effective. This was because, it said, after 23rd of November, Goldman made further margin calls in different amounts. Videocon argued that the later margin calls superseded the earlier ones, so that the notices of potential event of default and termination, being based on the earliest margin call, were ineffective because the obligation to make the margin demanded did not remain outstanding. However, the court found that the Credit Support Annex allows for successive margin calls to be made, and that Goldman had not indicated that the initial margin call was withdrawn. Another argument Videocon raised was that the early termination notice was not delivered until after close of business on the 2nd of December 2011, and so could not effectively designate the 2nd of December, or even a later date, as an early termination date. The judge found, on the evidence, that the notice was delivered and was effective on the 2nd of December. However, even if it had not been, it would still have been a valid notice. Under Section 6A of the Master Agreement, following an event of default, the non-defaulting party may designate a day as an early termination date. Videocon argued that the requirement of this section is that a day is designated and that Goldman's designation of the next local business day on which the notice is effective did not amount to the designation of a day. However, the court found that the notice did comply with Section 6A. It did designate one day rather than more than one day, and simply recognised that a day other than the delivery day could be the date that the notice is deemed to be effective. The judge therefore found that Goldman was entitled to summary judgment on the issue of liability. However, Videocon also disputed Goldman's calculations. The schedule to the parties' master agreement specified loss and second method to calculate amounts due. These definitions required, amongst other things, that Goldman A. provide a statement to Videocon showing its calculations in reasonable detail, B. if Goldman determined its loss by reference to market quotations, obtain quotations from one or more leading dealers in the markets and show in reasonable detail all relevant quotations, and C, determine loss reasonably and in good faith. Relying on these provisions, the court found that the calculation statement was defective in the following respects. First, the statement did not show any of the calculations Goldman had made, other than the addition or subtraction of total sums, so it lacked reasonable detail. Second, it did not show any of the quotations used, so did not show in reasonable detail all relevant quotations. Third, the statement said that Goldman used quotes that were more favourable for Videocon. The quotations were said to be from a Goldman Sachs entity and a third-party source, but did not say who these entities were or which had produced the more favourable quote. The statement therefore failed to meet the requirement that quotations be from one or more leading dealers in the relevant markets. Fourth, the statement referred to an options pricing model, but did not say what the model was or how it was used. This failed to meet the requirement that the statement show the calculations in reasonable detail. In the circumstances, Goldman was not entitled to summary judgment on the issue of quantum. This case is a useful confirmation that the Credit Support Annex allows for successive margin calls to be made without invalidating earlier margin calls, and that a termination notice does not have to refer to one particular day when the notice will be effective, if there is some doubt about when the effective date will fall. However, it also underlines the need for parties to take great care when preparing and delivering notices relating to the termination of ISDA Master Agreements. Calculation statements, in particular, must be accurate and full and comply strictly with the requirements of Section 6 of the Master Agreement. The second case I'm going to consider is a recent Court of Appeal decision, Lehman Brothers International, which I will call Libby, and Lehman Brothers Finance, which I will call LBF. It is the first case in which an English court has had to consider the provisions of the 2002 version of the Master Agreement dealing with the closeout amount payable on early termination, and indeed is one of the very few cases to consider the 2002 agreement at all. The Libby and LBF case came before the courts in the wake of a number of recent decisions dealing with the proper method of assessing the closeout payment upon termination under the 1992 agreement, including, most recently, the Court of Appeal's decision last year in Lomas and JFB Firth-Wixon. In all of those cases, it was held that the assessment of the closeout payment had to be made on the basis of a clean valuation, that is, on an assumption that the terminated transaction would have run to term, even if in fact that was unlikely to happen. The question in Libby and LBF was whether the same assumption had to be made under the 2002 form. The judge at first instance held that it did. The background to this case was as follows. Libby laid off risks arising from its derivative trading with clients by entering into back-to-back mirror transactions or intercompany transactions with LBF. The back-to-back transactions were carried out on the terms of an ISDA Master Agreement which followed the form of the 1992 Master Agreement, but was modified to incorporate certain provisions of the 2002 agreement dealing with the consequences of termination. I will therefore, for simplicity, refer to it as a 2002 Master Agreement. In this connection, Libby signed a side letter with LBF. The side letter provided for automatic termination of an intercompany transaction if the related client transaction terminated, and for Libby to pay to LBF under any intercompany transaction only the amount actually recovered from the client under the related client transaction. Accordingly, the side letter gave Libby important and valuable rights. In September 2008, an event of default under the intercompany transactions occurred in respect of LBF because its ultimate parent company became insolvent, with the result that those transactions automatically terminated. Libby was therefore the non-defaulting and determining party. That said, it soon went into default itself in respect of the client transactions. The consequence of LBF's default was, as I described earlier, that there had to be a determination of compensation by closing out the intercompany transactions. This involved Libby determining gains or losses at the date of the closing out in replacing or providing the economic equivalent of the material terms of the intercompany transactions. The key issue was whether the provisions of the side letter should be treated as terms of the replacement contract for the purposes of closing out the intercompany transactions. In other words, should the possibility of the client transactions terminating and the resultant effects of that under the side letter be taken into account for valuation purposes. At first instance, Libby had argued that the terms of the side letter were part of the material terms of the intercompany transactions for the purpose of the definition of closeout amount and should therefore be included in the valuation process. LBF, on the other hand, submitted that they should not be included and that a valuation had to be achieved in accordance with the value clean principle, i.e. the valuation had to be carried out on the assumption that conditions precedent were deemed to have been fulfilled and that the transaction would run to term. The judge at first instance held that the side letter was not a material term of the intercompany transaction and that it should be excluded from the valuation process. He held that when working out the closeout payment, the parties had to ignore the possibility that the transactions would have terminated early, as was provided for in the side letter. Libby appealed the judge's decision. The Court of Appeal held that the side letter should be taken into account for the purposes of determining value under the closing out provisions of the 2002 agreement. The basis on which the Court of Appeal reached its conclusion can be broken down into 4 principal points. First, it said that the 2002 agreement should be interpreted according to its own terms and taking into account all the relevant factual background. The decision in Lomas and JFB Firth-Rixson and the other cases did not establish the value clean principle for the purposes of the 2002 agreement. The previous cases were not authority on the interpretation of the 2002 agreement. The scale of the changes between the 1992 and the 2002 forms should not be underestimated. In particular, the relevant content of the replacement contract, whose economic equivalent is to be ascertained, had been expanded from payment obligations to all the material terms of the transactions. Option rights were now included in the valuation, and there is now direction in the 2002 agreement that the quotation for the replacement transaction could have regard to the determining party's own creditworthiness. I will refer to these changes again shortly. Secondly, the user's guide to the 2002 agreement suggested that the changes were more important than the retention of the value clean principle. On the other hand, there was no statement in the user's guide that the value clean principle was to be retained. Third, the alleged value clean wording appeared in the 2002 agreement in a different context from that in which it appeared in the 1992 agreement. The value clean principle in the 1992 form was said to apply because of the words in the definition of market quotation, assuming satisfaction of each applicable condition precedent. Similar wording was in the 2002 Master Agreement. The relevant words were assuming satisfaction of the conditions precedent in clause 2A3. However, they appeared in a different context. The Court of Appeal said that where more than one meaning is possible, the court should prefer that which is more consistent with business common sense. The judge's application of the value clean principle conflicted with business common sense. It was clear that the value clean principle in the 1992 agreement could produce unreasonable results. The effect of the judge's decision was that a party may be overcompensated on the ascertainment of the closeout amount because the possibility of early termination had been left out of account. It would be consistent with the reasons for the changes to the closeout provisions to seek to minimize results that were contrary to business common sense. The court looked at the addition to the closeout amount wording in the 2002 agreement of the words material terms and option rights, i.e. the impact of the requirement that the determining party now look to the material terms of the terminated transaction and the option rights of the parties in respect of the terminated transaction. It found that material terms are those that impact on pricing and would, in the present case, include the terms of the side letter. Material terms are plainly not limited to those about payment and deliveries. The Court of Appeal said that the judge's restriction on the meaning of option rights to options which did not amount to a right of early termination was not justified by the words used to describe option rights in the definition of closeout amount or by the user's guide. The wording plainly included option rights which amounted to a right of termination. The words assuming satisfaction of the conditions precedent in clause 2A3 in the 2002 agreement therefore could not be taken to deprive the references to material terms and option rights of the weight that they would otherwise have. The value clean wording appeared in a very different context in the 2002 form. Finally, the inclusion in the closeout amount of permission for the determining party to take account of its own creditworthiness involved a clear departure from the value clean principle. This is because it allowed the market maker's price to be affected by a perception of credit risk, which was inconsistent with an assumption that the transaction could be fully performed. To conclude then, in previous decisions dealing with the 1992 agreement, the courts had found that closeout had to be valued clean, i.e. assuming that conditions precedent were fulfilled and that the transaction would be continued to maturity. The court in this case, however, found that this principle did not apply to the 2002 agreement. This shows that the two forms can give rise to very different results. The decision is therefore of considerable importance for the derivatives market in general and provides welcome clarification of a key provision of the 2002 agreement.